Is my Texas non-compete enforceable? I'm Zach Wolf. I'm a Texas trial lawyer, and I get that question a lot. Sometimes from the employee, other times from the employer. So an employee might call me up and say, look, I've got a non-compete I signed with my company, but I really want to leave and go to work for a competing company. If I do that, what's going to happen? Is my non-compete going to be enforced? Or the employer might come to me and say, hey, I just lost one of my best salespeople. She signed a non-compete, but she left the company and now she's taking business away from us. In those situations, to figure out if the non-compete is enforceable, the first thing I look at is the Texas non-compete statute. It has two requirements. Number one, the non-compete has to be ancillary to an otherwise enforceable agreement. Oddly enough, I call this the ancillary requirement. Marker, please. Thank you. So it has to meet the ancillary requirement. Number two, a Texas non-compete has to be reasonable. I call this the reasonableness requirement. Let's break these down a little bit. What does it mean ancillary to an otherwise enforceable agreement? The typical way that Texas companies meet the ancillary requirement is to have a non-compete that is tied to a confidentiality agreement. In that typical situation, the issue usually comes down to this. Did the company actually provide confidential information to the employee? If the answer is yes, then the non-compete probably meets this ancillary requirement. The second requirement says that a Texas non-compete has to be reasonable in time period, geographic area, and in the scope of activity that it restrains. Now, if the agreement is unreasonably broad, that's not the end of the story, because the Texas non-compete statute also says that a judge is required to reform an overbroad non-compete to the extent needed to make it reasonable. Reform is just kind of a fancy legal word for rewriting the agreement. So if the agreement's too broad, the judge is supposed to rewrite it to make it reasonable. So there you have it. Now you know whether your Texas non-compete is enforceable or not, right? Well, not so much. Obviously, it's more complicated than that. It's not enough just to quote the statute. Any lawyer can look up the statute and tell you what I just said about these two requirements. To really understand whether your non-compete is going to be enforceable, you have to understand the Texas case law that applies these two statutory requirements. If you want an excellent and concise overview of how Texas courts apply those two requirements, you can go to my blog, 5 Minute Law. Go to 5minutelaw.com, and I have a post called What a Litigator Looks For in the Typical Texas Non-Compete. And there I lay out in a little more detail how Texas courts apply these requirements and what I look for specifically to figure out if a non-compete is enforceable. But that's really not enough, because clients don't just want to know, is this non-compete enforceable in the abstract or in theory? It's not an academic question. The practical question is, what's going to happen if there's a lawsuit over this non-compete? You're not going to know the answer to the question until a judge actually rules on it. And obviously, litigation takes time and costs money. So let's say you're the employee who's about to leave or thinking about leaving. You need to ask yourself, if I get sued by the employer, how much money can I afford to spend on the lawsuit defending myself? Or if you're the company trying to decide whether to file a lawsuit against an employee to enforce a non-compete, ask yourself, how much business is that employee actually likely to take from me, and how much is that lawsuit going to cost me to pursue? It's not enough to understand the legal principles for Texas non-competes. You have to have an understanding of what it's going to cost to litigate the issue.